Dear students, today I am going to discuss about implementation mechanisms and procedure under the ICCPR, that is International Covenant on Civil and Political Rights. There is an assumption that civil and political rights create immediate state obligations, while economic, social and cultural rights require a pragmatic implementation. An immediate obligation means a duty to implement the obligations undertaken under a treaty upon becoming a state party to the covenant, irrespective of the available resources. A progressive implementation, however, means a mere promotional type of commitment to enhance a certain objective and to realize it progressively, depending on the availability of the necessary resources. A comparison with the ICESCR, that is International Covenant on Economic, Social and Cultural Rights, seems to support the assumption that ICCPR creates immediate and unconditional obligations of implementation because the wordings of Article 2, Para 1 of the Covenant provides that each state party undertakes to respect and to ensure the covenant rights without making reference to the progressive realization as in the ICESCR. The two primary mechanisms of the covenant are its reporting procedure and its interstate complaints procedures. Article 40 of the International Covenant on Civil and Political Rights, that is ICCPR, requires that state parties submit reports to the Human Rights Committee on the measures they have adopted which give effect to the rights recognized in the covenant and on the progress made in the enjoyment of those rights. The committee then examines the reports and submits general comments to the state parties. Article 41 provides the option of an interstate complaint mechanism, but before state parties may file a complaint against another state party, both states must have exercised the option of making a declaration of their recognition of the committee's jurisdiction to consider interstate communications. The optional protocol of the covenant, adopted as a second treaty and also its coming into force in 1976, provides procedures by which individuals may file petition in the Human Rights Committee, that is HRC, in regards to violation of their rights under the covenant. In certain states such as the Netherlands, the ICCPR has direct effect and is therefore part of a state party's domestic law. Alleged breaches can be litigated in domestic courts. In other states, the ICCPR is not self-executing and so is not automatically part of municipal law. For example, the UK, India and Australia, the ICCPR has not been so incorporated. However, in these states, municipal laws of various kinds protect the rights contained in the ICCPR. More particularly, the ICCPR in a nutshell includes the following civil and political rights, which are also available in the Constitution of India either in the forms of fundamental rights or as other legal rights, like right to life, liberty and security of persons, freedom from slavery and torture, equality before the law, protection against arbitrary arrest, right to a fair trial, right to own property, right to political participation, right to marriage and found family, fundamental freedom of thought, conscience and religion, opinion and expression, freedom to assemble peacefully and form unions and associations, right to take part directly or indirectly in the government of the country. India accedes to the ICCPR on 10th April 1979 and the covenant became effective for India on 10 July 1979. In its initial report, India has submitted that many of the human rights and freedoms in the ICCPR have been guaranteed in the Constitution of India. The ICCPR is monitored by a United Nations committee known as the Human Rights Committee, popularly known as HRC. The committee is composed of 18 independent members experienced in the areas of human rights covered under the ICCPR. Although nominated by their country, committee members serve in their individual capacities, not as representatives of their countries. The committee meets 3 times in a year to review periodic reports from countries that have ratified the ICCPR. In these meetings, governments must provide an accounting of how they are implementing human rights standards under the treaty. The committee meets wish to influence the agenda, they must provide short written reports called list of issues submissions to the committee before it comes up with the list. In the next stage of the process, the country provides written replies to the list, which is then used as the basis to begin the dialogue during the in-person review. For the dialogue, the committee solicits and incorporates shadow reports from groups working on the ground with people these groups. Participation is essential here as well, as they begin or continue lobbying and advocacy efforts to get these and past recommendations implemented at home. The International Covenant on Civil and Political Rights was drafted to cover rights that protect physical integrity, procedural due process rights, and non-discrimination rights, as well as safeguarding the meaningful participation in the political life of one's society, including rights such as freedom of expression, assembly and association, and right to vote. As of June 2004, there were 150 state parties to the ICCPR, 104 parties to the first optional protocol, and 51 parties to the second optional protocol. The number of states parties to both the ICCPR and the first optional protocol increased considerably following the end of the Cold War, when human rights became a less politicized discipline within the United Nations. The United States, a long-term absentee, ratified the ICCPR in 1992, and in the same year, the first optional protocol entered into force in the Russian Federation. With the creation of new states in the former Soviet Union and Eastern Europe, the view has been taken that these successor states have automatically succeeded to their predecessors' obligations under the ICCPR and the optional protocols. For example, the People's Republic of China has continued to submit reports to the monitoring body of the ICCPR, the HRC, on behalf of Hong Kong, since it acquired the territory from the United Kingdom in 1997, even though China itself has signed but not ratified the treaty. Upon ratification of the covenant, a state party may come into a reservation process to one or more of the provisions. The reservation process renders the reserve provision non-binding for the state party concerned. The International Law Commission, in its draft guidelines, defined a reservation as a unilateral statement, however phrased or named, made by a state or an international organization when signing, ratifying, formally confirming, accepting, approving or acceding to a treaty, or by a state when making a notification of succession to a treaty whereby the state or organization purports to exclude or to modify the legal effect of certain provisions of the treaty in their application to that state or to that international organizations. A reservation can also act partially to reduce the effect of a certain guarantee rather than nullify its application. There is no doubt that reservations diminish the effectiveness of treaties, and the ICCPR is not an exception in this regard. Reservations may be distinguished from other statements issued by states parties when ratifying the ICCPR. These statements are known as understandings or more commonly as declarations. These statements give notice of a state's interpretation of the covenant and have no legal effect in international law. The International Law Commission defined an interpretative declaration as a unilateral statement, however phrased or named, made by a state or by an international organization whereby that state or that organization purports to specify or clarify the meaning or scope attributed by the declarant to a treaty or to certain of its provisions. The HRC, that is Human Rights Committee, observed in paragraph 3 of its General Comment 24 that it is not always easy to distinguish a reservation from a declaration as to a state's understanding of the interpretation of a provision or from a statement of policy. Article 4 of the ICCPR deals with the contentious issue of derogations. According to commentators, the right of derogation, like the right of reservation, may represent a necessary evil, whilst it is arguable that civil liberties must be curtailed during public emergencies to ensure general public security. It is also true that some of the most heinous human rights abuses occur during purported public emergencies. It is, therefore, utmost importance that derogations to the covenant are strictly monitored and so do not serve as a smokescreen for the destruction of rights. Derogations, of course, can only be entered in time of public grave emergency, and the text of Article 4 guarantees that this emergency must reach a certain severity and that some provisions may not be derogated. According to the preamble of the first optional protocol, the Human Rights Committee is given competence to consider communications from alleged victims in order to further achieve the purpose of the ICCPR. Under Article 1 of the protocol, a state party recognizes the competence of the HRC to receive and consider communications from individuals subject to its jurisdiction who claim to be victims of a violation by that state party of any of the rights set forth in the covenant. The communication submitted to the HRC must be in written form and all available domestic remedies must have been exhausted. The HRC's consideration and examination of communications is conducted in private and its final views are published. The International Covenant on Civil and Political Rights is an international human rights instrument specifically aimed at protecting civil and political rights. This category of rights is usually referred to as first generation rights. The development of the human rights principles under the covenant have a long history, and its proper effective implementation will definitely make the covenant a great success. Apart from the above discussions, the most important feature of the covenant is that it is an universal instrument containing the binding of legal obligations for states parties that aims to protect stateless persons as well as nationals. A large number of states parties to the covenant has made the fact clear that many of its provisions are now becoming the part of customary international law.